petition which merely allege irregularities and/or malpractice without specifying the particular polling units or particular collation centers where the irregularities or malpractices have taken place will be regarded as proper, merely because the respondent has not requested for further petition. Also, when an election petition is by nature a declaratory action, in which the petitioner succeeds only on the strength of his own case and not on the weakness of that of the Ibusari versus Adepoju, Oetola versus Adeleke, and Anazon versus Unubogu petition. It is in this respect that the petitioner has an obligation to set up a clear, unambiguous, precise, and positive case in his pleadings, since pleadings is the foundation of the party's case, and it is to the pleadings that the parties to litigation as well as the court are all bound. TNM and others versus. It is in the light of all the foregoing that I find and hold that the motions of the respondents listed above succeed. In consequence, paragraphs 9, 60, 61, 66, 67, 68, 69, 70, 71, 72, 73, 76, 77, 78, 83, and 99 of the petition, which have failed to state the specific polling units, collation centers, or the specific places where the irregularities and malpractices are alleged to have occurred, or the figures of votes which are being claimed are grossly vague, imprecise, nebulous, and bereft of material particulars, and have thus failed to meet the requirements of paragraph 4 of 1 sub D of the Electoral Act 2020. According to paragraph 4 sub 7 of the said schedule, said paragraphs are consequently hereby struck. On the first respondent's prayer to strike out paragraphs 57 and 58 of the petition for being inconsistent with paragraphs 65, 67, 70, and 71 of the petition, the essential contention of the first respondent is that while paragraph 57 and 58, whilst in paragraph 57 and 58 of the petitioners have alleged that the first respondent failed to comply with the order of inspection granted by the court, petitioners have in paragraph 65, 67, 70, and 71 stated that they will rely on the report of the inspector. Additionally, first respondent also argued that the first petitioners have alleged that the election was marred by corrupt practices and was not conducted in sufficient compliance with the Electoral Act. They have also alleged that they have scored majority of no football cards and should be declared the winner. Plan on some cases which are elusive, first respondent urged the court to strike out the paragraph as well as prayers 1 to 4 on the one hand, and prayers 5 sub 1 and sub 2 on the other hand for being inconsistent.
So far so good. So far so good. So far so good. I don't see Peter Obi winning this stuff. The judgment so far so good has been in the favor of APC. Even now, all in favor of APC. But currently, there's a massive protest. Massive protest in Eagle Square, Federal Capital Territory. Protests involving APC members, PDP members, and Labour Party members. They have clashed. It's not as if a fight. Some are supporting the APC. All those women here, they came out to support Asiwaju. Meanwhile, there are still other people came out to support Atiku. While there are others who also came out to support Peter Obi. So they just clash for Eagle Square. But I think we all know those ones that are politically motivated. Let's still listen, guys. Let's do this.
In any case, first respondent, which is the body that conducted the election and to whom the first petitioner's nomination documents were submitted by the second petitioner, admitted in paragraph 4 of the petition, wherein petitioners award that the first petitioner was duly sponsored by the second petitioner, whose platform the first petitioner contested. Therefore, no hesitation in its countenance in this ground. Second category of objections or applications. These are the categories that challenge the competence of the petition on some of its grounds. Second category of the respondents' applications that challenge some of the grounds of the petition and or the competence of the petitioner as follows. First, respondents' motion filed on the 19th of April 2023 seeking 1. Order striking out ground 2, paragraphs 333 to 79 and release 5, 1 and 2 of the petition on transmission of election results for being cut off by issue ESCO. 2. Order striking out paragraphs 20, 1, 21, 23, 24, 25, 26, and 27 for nomination of the second and third respondent for lack of jurisdiction. Second and third respondents' motion filed on the 12th of May 2023 seeking for the following. 1. Order striking out or dismissing the petition for being incompetent and defective. 2. Order striking out grounds 1, 2, and 3 of the petition. 3. Order striking out release 1, 1, 3, 2, 3, 4, 1 to 4, 5, 1 and 2 of the petition. The above two motions are predicated on several grounds, which are reproduced here. It is a view of this court that the issue relating to ground 1, challenging the qualification of the second respondent to contest the election, the issue relating to the competence of ground 2, relating to the allegations of corrupt practices, non-compliance with the Electoral Act 2022, and the plea of estoppel relation thereto, as well as the issue relating to competence of the relief sought in this petition, are matters on which the parties have joined issues in the main petition, the merits of which will be decided after considering the pleadings and evidence laid in it. It is the settled position of law that a court should not comment on or decide at preliminary stage matters or issues which are supposed to be decided in subsequent cases. Iwonko and others was Eradwal. Ocholi on Onojo James SAN versus INEC petitions on the. Hence, while leaving those issues to be dealt with on the merits of the petition, we shall determine at this stage the objections relating to the petitioner's locus standi, the non-joinder of necessary parties, and the objection to the competence of the petitioner's replies, the respondent's replies, or some paragraphs of the petitioner's lack of locus standi of the first petitioner. Second and third respondents and the fourth respondents in his motion filed, their motion filed on the 8th of May 2023, also objected to the first petitioner's locus standi to bring this petition. Principal contention is that the first petitioner was in contravention of section 77 sub 3, the Electoral Act 2020. They argued that the first petitioner, who was a member of the People's Democratic Party and who was screened as one of its aspirants for the presidential election, only resigned his membership to that party on the 24th of May 2022, joined the second petitioner on the 27th of May 2020. They contended that as at 30th of April 2022, first petitioner could not have been in the register of members, second petitioner, which it submitted first respondent 30 days before the presidential primary election, as mandated by section 77 sub 3 of the Electoral Act. Since the first petitioner is not in the membership register submitted by the first respondent by the second petitioner, first petitioner lacks the locus standi to challenge the outcome of the election. Our contract, petitioners submitted that the issue of membership of a political party is a domestic affair of the political party concerned. The court lacks the jurisdiction to entertain, relied on the cases that are reproduced. The courts have consistently held in a plethora of cases that the issue of membership of the political party is an internal affair. It is not a justiciable issue, and courts have no jurisdiction to this. TNM versus Asuko, others, Tani and Galadima, and Tubido versus INEC, citations on the record, as well as all the cases cited over election. The provision of section 77 sub 3 of the Electoral Act 2022, which only mandates every political party to submit the register of its members 30 days before its party primaries, cannot be invoked by the respondents for the purpose of challenging the first petitioner's membership to the second petitioner. It is only the second petitioner that has the sole prerogative of determining who are its members. And having sponsored the first petitioner as a candidate for the presidential election, first petitioner has satisfied the requirement of being a member. Second petitioner has provided for in section 131 sub C, the 1999 Constitution. It is not within the rights of the second and third respondents and the fourth respondent question the first petitioner's membership, second petition. This ground of objection is hereby overruled. Non-joinder of registry parties. First respondent in his motion of 19th of April 2023, and the second and third respondents, as well as the fourth respondent, raised the issue of non-joinder of Abubakar Atiku or the People's Democratic Party, who came second in the presidential election as respondents to the petition. The contention of the respondent then is that since by relief 1 Roman 3, 4 Roman 4 of the petition, petitioners who came third the presidential election are seeking to be declared the winners of the election. Petition cannot be effectually and completely determined without the joinder of Abubakar Atiku or the People's Democratic Party, who came second in the election, as respondents to the petition. For that reason, the respondents have contended that this court lacks jurisdiction to gain the petition as constitutional. Great reliance on JJD and INEC. Buhari and Obasanjo petition on the third position, however, petitioners relied on the cases of Obasanjo and Yar'Adua, Buhari and Yusuf, Akoti and INEC, and contended that only statutory respondents provided in Section 133 of the Electoral Act 2022 are necessary parties to petition. Petitioners are not under any obligation to join Abubakar Atiku and the People's Democratic. By Section 133 of the Electoral Act 2022, the statutory respondents and election petition are 1. The person whose election is being complained of, and 2. The Independent National Electoral Commission, which would also be deemed to be defending the petition on behalf of its officers whose conduct complained of. In the cases of Obasanjo and Yar'Adua, Buhari and Yusuf Supra, cited by the petitioners, the Supreme Court categorically held that only the statutory respondents stated in Section 133 of the Electoral Act are necessary parties, and that losers at an election who are not statutory respondents are not necessary parties at an election. By the import of Section 133 of the Electoral Act 2022, the contest in an election petition is strictly between the petitioner who challenges the outcome of the election, the person who was declared the winner of the election, and the commission that conducted and declared the outcome of the election. This means that every candidate who lost the election and who is desirous of challenging the outcome of the election is expected to file his own petition against the winner of the election, and in so doing is not required to join any other candidate who lost the election like himself. It is in furtherance of this that paragraph 50 of the first schedule to the Electoral Act 2022 requires an election tribunal or court to consolidate two or more petitions which are presented in relation to the same election or return. As rightly submitted by the petitioners, the case of JJD and INEC cited by the first respondent is clearly not applicable to this case. This is the decision in that case is that my Malabuni was a necessary party because by the provisions of Section 183 of the 1999 Constitution would have ceased being a governor of Yobe State if the case made out in the petition that he could not combine the offices of governor of Yobe State, acting chairman of the All Progressive Congress is sustained. In this case, Abubakar Atiku, People's Democratic Party, who were only runners-up in the presidential elections, are not necessary parties, as they are not statutory respondents to this petition. The petitioners herein have no obligation to join them in this. Again, in Buhari and Obasanjo Supra, relied upon by the respondents, the Supreme Court reconfirmed its decision in Buhari and Yusuf Supra that there is no obligation on the petitioner to make a candidate who lost an election like himself a respondent to his petition. Also, as in this case, Abubakar Atiku and the People's Democratic Party have filed a separate petition
all those people now for this matter.
0523, which, as mentioned in the earlier part of this court has consolidated in the petition, paragraph 50, the first schedule to the Electoral Act 2020. This ground of objection to the competence of the petition are meritorious, accordingly overruled. On the arguments over the competence of the relief sought in this petition, it is my view that the relief which the court an election petition as statutory, as provided in Section 136 of 1, of 2, of 3 of the Electoral Act 2020. Therefore, the determination of whether the relief sought by a petitioner are grantable will only be made after trial. Challenge to competence of the petitioner's replies. The third category of the applications of the respondents seek to strike out the petitioner's replies or some paragraphs of the replies. These are first respondent's motion filed on the 9th of May 2023 seeking 1. order striking out the petitioner's reply, the first respondent's reply for being incompetent. 2. In the alternative, order striking out paragraph 15, 16 Roman 1 to 7, 17 to 20, 22, 24, 25, 27 to 32, 34, 36, 37, 38, 40, and 41, petitioner's reply, offending the provisions of the first schedule to the Electoral Act. Second and third respondents' motion filed on the 13th of May 2023, seeking for order striking out petitioner's reply of 21st April 2023 for being incompetent. 2. In the alternative, order striking out paragraphs 8 to 17, 19 to 32, 34 to 42 of the petitioner's reply for introducing new facts. Fourth respondent's motion filed on the 8th of May 2023 prays for 1. Order striking out paragraphs 15 to 32 of the petitioner's reply, the fourth respondent's reply, as well as the witness statement on oath, with failure to deny the fourth respondent's allegation. 2. Order striking out paragraphs 5 Roman 1 to 9, 15 Roman 1 to 7, 16 Roman 1 to 7, 17 Roman 1 to 7, 18 Roman 1 A to H, 18 Roman 2 A to E, 18 Roman 3, 5 and 7, A to B, A and B, Roman 8 A and B, Roman 9, Roman 11, 20 to 25, A to D, 26 Roman 1 and 2, 27 to 31 of the petitioner's reply, the fourth respondent's reply for raising new issue. All the respondents challenge the competence of the petitioner's reply, their respective replies, or in the alternative the paragraph thereof, which they have variously listed above. Their essential contention is that the replies or in the alternative the paragraph thereof have either raised or introduced new facts aimed at substantially altering the grounds and reliefs in the petition, or are mere repetition or rehash of the facts contained in the petition, contrary to the provisions of paragraph 16, sub 1A and B, the first schedule to the Electoral Act. Respondents replied on several shell authorities. The response, the petitioners have argued that they have merely reacted to the fresh/new issues raised in the replies of the respondents, which attempted to justify the grounds of non-qualification, the second and third respondents, as well as the non-compliance by the first respondent, the Electoral Act 22. They relied on Silva and INEC, PDP versus Ezo Muka, petitions on the record, as the court to discountenance objections of the respondents of both the petitioners. Paragraph 16, sub 1, of the first schedule to the Electoral Act 2022 provides as follows, and I quote, if a person in his reply to the election petition raises new issues or facts in defense of his case, which the petition has not dealt with, petitioner shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, petitioner's reply and answer the new issues of fact. So, however, that A. Petitioner shall not at this stage be entitled to bring in new facts, grounds or prayers tending to amend or add to the contents of the petition filed by him. Quote. By the import of paragraph 16 sub 1A of the first schedule, petitioner may, in filing a reply, respond to allegations of new facts raised in the respondent's reply to the petition, provided he does not in so doing amend or add to the petition. It is instructive to observe that the words used in paragraph 16(1)(a) are, quote, new facts, grounds or prayers tending to amend or add to the contents of the petition, unquote. The word new suggests something which is not there, while the word amend signifies modification. Add, on the other hand, means to increase. What the provision emphasizes, therefore, is that the reply of the petitioner must strictly be confined to the new facts raised in the respondent's reply and must not go over that to attempt to amend or add to the petition. See All Progressive Congress versus People's Democratic Party, Igadi and Wamako, Adepoju versus Awo Duyilemi, Ikoro versus Zunaso, citations on the record. Indeed, it's simply explaining the new issue which should attract the reply. The Supreme Court had held in Ejesimba versus Onuzuriki as follows, and I quote, a new issue to attract a reply must not be really new in the sense of being brand and fresh. The issue must be really new, the statement of claim, in that it was not existing therein and was therefore brought into existence or introduced for the first time, the statement of defense by the defense. The new issue, both in both its contents and materiality, must be further and additional to the statement of claim. Thus, the mere fact that a defendant states his own side of the case does not necessarily make it new, particularly when the plaintiff has told a contrary story in his statement of claim. In such a situation, the case stated by the defendant amounts to joining issue of the plaintiff, and that does not bear the name of a new issue at all. The new issue arises where the plaintiff did not avert to or touch the contents of the defendant's armament in anticipation. The defendant's armament was produced pleadings for the first time and therefore unique and novel case. A careful examination of the petitioner's petition, the first, second, and third, and the fourth respondents' respective replies, and the replies which the petitioners filed in response thereof, reveals that apart from rehashing what they have already averred in their petition and denying what the respondents have stated in their respective replies, petitioners also introduce new facts in their replies, the respondents' replies, which were not contained in their petition. This is in clear contravention of paragraph 6 of 1A, first schedule to the Electoral Act. Paragraph 16, 1 to the law as encapsulated in paragraph 16(1)(a) of the first schedule to the Electoral Act quoted above forbids new additions or amendments by a petitioner which are not contained in the petition, because such new additions or amendments will prejudice the respondents and breach the respondents' fundamental right to fair hearing, guaranteed by section 36(5) of the Constitution of the Federal Republic of Nigeria 1990. Since the respondents will have no opportunity to respond to those new issues, additions, or amendments. See PDP, another was INEC, others. Maku, and another was Al-Makura, and other citations. An examination of the paragraph 4, Roman 3, Roman 4, and Roman 5 in the first respondent's reply shows that the paragraphs has not raised any new issue contrary to the assertion of the petitioners. In paragraph 15 of the arrest.
No, again, no. For me,
we have the sound to the Buddha way. The petitioner's armament in the same paragraph 15 that the first respondents officials at the polling unit failed to give clear copies of the results of the election from ECHA to the petitioner's agents, as the pin copies given by the petitioner's agents were very faint and unreliable. It's a new fact which tends to amend the petition. Paragraph 16, Roman 1, 7, 17, second part of 18, 22, 24 of the first respondent's reply are traversed of paragraphs 21, 27 of the petition. Hence, paragraph 16 of the petitioner's reply, which purports to respond to new issues in paragraph 17, 18, 19, 20, 21, 22, and 24 of the first respondent's reply, actually contain new facts, which will amount to amendment of the petition. Also, paragraphs 17, 18, 19, 24, 25, 27, 28, 29, 30, 31, 32, 34, 35, 36, 37, the petitioner's reply, the first respondent's reply are either a rehash of the facts already averred in the petition or contain new facts which will amount to amendment of the petition. In respect of the petitioner's reply to the second and third respondent's reply, the petition latter are seeking for an order striking out paragraphs 8 to 42 of the petitioner's reply. However, a careful examination of those paragraphs shows that only paragraph 21 of that reply has raised a new allegation. Then the first respondent of attempts to manipulate the data uploaded on the back-end server of the AWS. The same paragraph 21 of the petitioner's reply to the second and third respondent's reply is herewith. Similarly, petitioners have introduced new facts in paragraphs 16, 17, 18, 20, 22, 23, 24, 25, and 27 of their reply, some of which contain serious allegations to fourth respondents, which the fourth respondents have no opportunity. In contravention of paragraph 16 sub 1 of the first schedule to the Electoral Act, those paragraphs are also herewith. That indeed is the rulings on the respondent's objection, various objections.
But as I was trying to explain earlier before we went for the break, we took all the judgment. After that, my learned brothers will now their own that because the petitions are getting. So now we'll go to the main petition number 3. In bringing this petition, the petitioners who are contestants in the presidential election held on 26 February 2023 have challenged the declaration return of second respondent as the winner of the election and sought for the declaration and consequential reliefs, which I have reproduced in the beginning of this judgment. The petitioners have predicated their petition on the 3 statutory grounds earlier stated. Although in the ruling of this court on the objections of the respondents, some paragraphs of petition replies have been struck out for stated reasons, this court will take into consideration the entire affirmance in the petition and determine the merit otherwise of the petition in case of justice. At trial, the petitioners opened their case, tendering from the bar several certified true copies of electoral and other documents which were objected to by all the respondents, who reserved the reasons for their objection to the state of final address. Said objections were therefore admitted, the said documents were therefore admitted and marked as exhibits without prejudice to the objections of the respondents. The court ordered the respondents file separate addresses on their objections along with their final addresses. Proof of their petition: the petitioners called 13 witnesses who gave evidence as PW1 to PW13. Of those witnesses, only 3 had their witness statements on oath filed along with the petition, while the other 10 were subpoenaed witnesses whose statements were filed separately after hearing in the petition had commenced. The respondents objected to the competence of the subpoenaed witnesses, give evidence and adopt their addresses and witness statements on oath, and reserve the rulings for their objection to the state of final address. That prejudice to the objection, state witnesses adopted their respective witnesses' statement on oath, after which they were duly cross-examined by all the senior counsel for the respondents. Upon closure of the petitioner's case, the first respondent as well as the second and third respondent called one witness each in their defense. All the respondents did not call any witness, but opted to rely on the evidence already adduced by the other respondents, and that is state under cross-examination on behalf of the fourth respondent. At the close of evidence, parties file and extend their respective final addresses, including separate addresses, in support of their various objections which they raised in trial. So we shall now consider the respondents' objections to the competence of some of the petitioner witnesses and to the documents tendered by them during trial. To save time, keep the addresses of counsel, go to the resolutions of this issue. So, the resolution of the respondent's objection to witnesses and documents contained in the 84 of the judgment. In the first statement, the respondent's objection, all the respondents challenged the competence of PW3, PW4, PW5, PW6, 7, 8, 9, 10, 11, and 13. And the respondent's essential contention is that the witness statements on oath whose witnesses, on oath of those witnesses, all the petitioners were not loaded along with the petition, but were only filed during trial, contrary to paragraph 4 of 5B of the pay schedule to the Electoral Act 2020. Section 208.5 of the 1999 Constitution as amended, which limits the time for presenting the election petition, provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the election. In the same vein, Section 132, sub 7 of the Electoral Act 2020 provides as follows. An election petition shall be filed within 21 days after the date of the declaration of the result of the election. Paragraph 4 of the first schedule to the Electoral Act 2020 stipulates the content of an election petition which shall be filed. In particular, paragraph 4.5 of the state schedule reads as follows. The election petition shall be accompanied by a list of the witnesses that the petitioner intends to call in proof. B. Statements on oath of the witnesses. C. Copies or list of every document to be relied on at the hearing of the petition. Paragraph 6 of that paragraph, a petition which fails to comply with the above requirements shall not be accepted for filing. Paragraph 14 sub 2 of the same first schedule, the Electoral Act, then provides as follows. After the expiration of the time limited by A, Section 132 sub 7 of this Act for presentation of the election petition, no amendment shall be made. 1. Introducing any of the requirements of paragraph 4.1 contained in the Tribunal election petition file, or 2. Effecting substantial alteration of the ground for or the prayer in the election petition, or 3. Except anything which may be done under subparagraph 2A, Roman 2, affecting a substantial alteration of or addition to evidence of facts relied on to support the ground for or sustain the prayer election petition. And sub B, paragraph 12. Following the reply, no amendment shall be made. 1. Alleging that the claim of the seat or office by the petitioner is correct or false. 2. Except anything which may be done under the provisions of paragraph 2A, Roman 2, affecting any substantial alteration to or addition to the admissions or the denials contained in the original reply file or to the facts set out in the reply. The above quoted provisions of the Constitution, Electoral Act 2020, and the first schedule thereto have been thoroughly considered by the Supreme Court in several cases, including Okian and other versus Mimiko and others, Gumbi JC, Oba and Vincent, Ragume and others, Anik, Okuru, Ogi and others, PDP and Okuru and several others listed here. In Oke and Mimiko, the upper apex court, Gumbi JC held as follows on the court. Paragraph 4, 1 and 5 of the first schedule to the Electoral Act, the composite analysis of an election petition has been dealt after spelled out, and also a list of materials which must be accompanied. The use of the word shall in the subsections is very instructive, mandatory, conclusive. In other words, the provisions do not allow for additions, and hence, the procedure adopted by the appellants in seeking for an extension of time is nothing other than surreptitious attempt to amend it. This is obvious from the nature and substance of the application, especially where one of the grounds seeks to put in facts which are allegedly not available allegedly not available at the time of filing the petition, but only came into their possession after the statutory time limit allowed for the presidential election petition. Expressly, there is no provision in the legislation which provides for extension of time. What is more, in paragraph 14.2 of the first schedule to the Electoral Act, the appellant by section 134 sub 1 of the Electoral Act has been totally foreclosed in any amendment, which was in fact the hidden agenda promoting the application. The saying is true that even the devil does not know a man's intention. It can only be inferred from the act exhibiting that which is conceived in the act. Mind. Use of the word shall in paragraph 14 sub 2A of the first schedule to the Electoral Act mandatory and places a complete bar to any form of amendment in file does not allow for an exercise of petition whatsoever. Further still, On a critical portion of the application, reliefs 2 seeks to all additional witness to which with AEO. It is pertinent to state that at the close of pleading, parties have submitted the list of witnesses who were to testify together with their deposition. The idea, purpose, and intention of the application is suggestive of nothing more but a clear confirmation seeking for an order of an amendment as rightly and ingeniously thought out by the trial tribunal and also affirmed by the lower court. This will certainly violate the provisions section 285.5 of the Constitution and 134 of the Electoral Act, clause of court. With his concurring judgment in the same case, Nguta, JSC, specifically stated follows the court. The additional or further witness depositions sought to be allowed for a just and fair determination of the petition are fresh facts, as found by the tribunal, and which finding was endorsed by the lower court. This court will not interfere with a concurrent finding of facts of the two lower courts when the appellants have failed to show special circumstances for this court to do so. Petitions are time-bound, and the court will not allow the party to resort to any sort of subterfuge or frustrate the intention of the Electoral Act that petitions post of discussing. The petitioners in this case have relied on the earlier decisions of this court in Omidiran versus Ete, Lasun versus Awoyemi, Tuka, to argue that the 15 witnesses whose witness statements on oath were filed outside the time limited for the presentation of the petition are competent to testify because they are subpoenaed witnesses who do not work for the petitioner. However, it is pertinent to observe that unlike in the present case, subpoenas issued at the instance of petitioner in the case of Omidiran and Ete, Lasun versus Awoyemi were decided under the Electoral Act of 2006, which did not have provisions similar to paragraph 4 sub 5, the first schedule to the External Electoral Act 2022. Secondly, the subpoenas in the above two cases were issued and served on adversaries, namely the resident electoral commissioners. Again, those two cases were decided before the introduction of Section 285 subsection 6 of the Constitution of Federal Government of Nigeria 1999, which mandates that an election petition shall be decided within 180 days from the date of filing the petition. Thus, whilst this court in Omidiran and Ete and Lasun versus Awoyemi appear to have adopted a flexible approach, the Apex Court had taken a strict approach in that decision for Oke and Mimiko. Indeed, in subsequent following the Apex Court's decision in Oke and Mimiko, this court, by arguing JCE as he then was, now JSC, elected this strict position of the law over versus Vincent at paragraph 46, 48, paragraph 8 begins, by detail as follows are court. I think that this court in Omidiran and Ete and the Supreme Court in Oke and Mimiko adopted different approaches in addressing the issue of whether the tribunal or court can allow a witness deposition or other document not filed along with the petition or not filed within the time allowed for filing election petition to be filed and used in an election petition proceeding. Omidiran's case did not strictly enforce the time limits prescribed in Section 141 of the Electoral Act 2006. The provision in the first schedule thereto in prohibiting the introduction of additional facts in the proceedings after the period allowed for filing a petition and closure of pleadings in paragraph 1 sub 1 of the Election Tribunal and Post Practice Directions of 2006 on the content and form of the petition, held that the purpose of the practice direction is to guide and regulate compliance with an observance of the provisions of the first schedule to the Act and the Federal High Court rule where applicable. This elastic application of the electoral laws by this court in that case is not in line with the current judicial approach of strict enforcement of electoral laws and the current approach of applying the Electoral Tribunal to post practice directions as overriding the rules of court in election court cases. In Mimiko, the Supreme Court approached the issue in keeping with the current judicial trend of strictly applying electoral laws and procedural rules and giving them supremacy over rules of court in election cases. The Supreme Court has consistently, in a long line of cases, insisted on this strict and inelastic approach opposing electoral law. The law has laid out schema juris in Oke and Mimiko is that a witness position that is not filed along with the petition within the 21 days allowed for filing the petition cannot be filed in the proceeding. It held thus, if there was an evidence which was fundamental to determination of the petition, that evidence ought to have been placed willy-nilly for the tribunal within the time limits specified by the Electoral Act or any other act. That evidence ought to be regarded as the spinal cord of the petition. Even if it has been withheld by any person, there are several ways to go about placing same before the tribunal. The Evidence Act is very clear on this. The petitioners ought to have restored that figure, close of court. The firm position of the Supreme Court, as stated in Okia Mimiko and followed by this court in Oba and Vincent Kupra, is that by the combined provisions of Section 855 of the 1999 Constitution, Section 137 subsection of the Electoral Act 2022, and paragraph 4, 5, and 6 of and 6 and 14.2 of the first schedule to the Act, every written statement on oath of the witness which a party intends to call must be filed along with the petition within the time limited by Section 208.55 of the Constitution of Federal Republic of Nigeria as amended, and Section 132 subsection 7 of the Electoral Act 2022. Once the time limited for filing of a petition has elapsed, the contents of the petition cannot be added to or amended in any manner or under any guise. Any written statement on oath of the witness filed outside that 21 days limitation will amount to a surreptitious amendment of the petition and a breach of paragraph 14 of the first schedule to the Electoral Act 2022. This is irrespective of whether the witnesses to be called are ordinary or expert witnesses and whether they are willing or in witnesses. Since then, this has been the consistent position of the law followed by this court. Indeed, in Okuru versus Obe, this court held this position by our learned brother Bolaji Yusuf, stated that support. From the records, PW3 and PW4 was summoned by subpoena issued by the tribunal and presented as expert witnesses. The question is whether this without more entitles the appellant to file their statements on oath outside the time set for filing the petition. Or a reply to the respondent's reply in answer to the petition, and of the humble view that whether an expert witness or not, a witness remains a witness. So the proviso to Order 3, Rule 3, Sub 1 of the Federal High Court, Procedural Rules 2009, made applicable to an electoral election petition by paragraph 54 of the first schedule to the Electoral Act, provides that the statements on oath of witnesses requiring subpoena from the court need not be filed at the commencement of the suit. 2. The witnesses who require subpoena or summons shall, at the instance of the party calling them, be served with civil form 1A before the filing of the statements that witness. The application of that rule is with regard to and was subject to the provisions of the Electoral Act, not independent of the Act. Paragraph 54 reads, subject to the express provisions of this Act, the practice and procedure of the tribunal or the court in relation to an election petition can be as nearly as possible similar to the practice and procedure of the Federal High Court. In the exercise of the civil jurisdiction, the civil procedure rules shall apply with such modifications as may be necessary to render them applicable, having regard to the provisions of this Act, as if the petitioner and the respondent were respectively the plaintiff and the defendant in an ordinary civil action. The provisions of the Electoral Act being a substantive law shall override any rule of court which is contrary to provision. The subsidiary legislation must conform with the principal law, CNMPC and Afamfa Oil Limited. The proviso to Order 3, Rule 3.1 of the Federal High Court Rules 2009 cannot override or affect or whittle down the absolute and mandatory provisions of Section 285 chapter 5 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, which stipulates that an election petition shall be filed within 21 days after the date of the declaration of the result of the elections, and paragraphs 4, sub 1, 5, and 14.1 and 2, the first schedule to the Electoral Act, which stipulate the content of a petition. It is therefore clear that in law, the provisions of Order 3, Rule 3.1 of the Federal High Court Civil Procedure Rule 2009 cannot provide a platform for filing and using witness statements on oath not filed within the time limit set for presentation of petition, and which time cannot be extended for any reason under any guise. The focus of our decision in Ogba and Vincent Supra was the injustice in allowing a piece of evidence not covered by the pleadings to be presented in the court when the opposing party would have no opportunity to react to it. It is my humble view that the position of the law, as can be gleaned from the section 2855 of the Constitution, paragraph 4, 14.2, and 16.1 of the first schedule to the Electoral Act, is that a petitioner cannot be allowed to file and use documents or witness statements on oath filed outside the time set for filing petition, and to which the respondents would have no opportunity to react. To do so will amount to creating an avenue which a petitioner can use to exploit or override the respondents. That is the stand of the Supreme Court, OK and Mimico, number 1 Supra, followed by this court, Oba and Vincent Supra, both of court. Again, in Ararume and another, and Anik and others, in which I wrote the lead judgment, therein are stated as follows. The law, therefore, is that the deposition of a witness must accompany the petition at the time of filing the petition. In other words, a written statement on oath of an intended witness must be filed along with the petition. Thus, any written deposition of a witness not filed along with the petition will not be countenanced by the court or tribunal. Therefore means that a written deposition filed by a witness not listed in the petition nor his deposition promoted cannot be countenanced by the court or tribunal after the expiration of the time prescribed for the filing of the petition. I think that is what the tribunal decided in this case, in line with the decision in Oba and Vincent. The combined effect of paragraph 4.5, Roman 1 and 2, 14.1 and 3 of the State Schedule to the Electoral Act is that no witness can testify in chief before a tribunal if he has not deposed a written statement of oath, which must necessarily have been filed along with the petition. Close of court. From the foregoing judicial decisions, it is clear that in election petition litigation, whether the witnesses which a party intends to call are ordinary or aspire witnesses, and whether they are willing or abstaining witnesses, their witness deposition must be filed along with petition before such witnesses will be competent to testify before the tribunal or court. It is instructive to observe that one of the leading senior counsel for the petitioners in this petition, Dr. Onyechi Ipiag in SAL, was the lead counsel to the second respondent in Arabume and another versus Anik and others, wherein he successfully challenged the competence of a supreme witness, Ama Ibom Abu, PW2, on the same ground that the witness statement on oath of the same witness was filed on 8/7/2019, long after the time limited for the filing of the petition. Therefore, the petitioners in this case were well aware of the certain legal position on supreme witnesses in election petitions, favored by the Supreme Court and by this court. Yet they embarked on subpoenaing PW3, PW4, PW5, PW6, PW7, 8, 9, 10, 11, and 13. 10 out of their 13 witnesses, whose witness statements on oath were not front-loaded along with the petition. The petitioners have tried to argue that the said witnesses are witnesses of this court. With respect, this argument is misconceived because the subpoena in respect of those witnesses were issued upon the response or the request of the petitioners. The application for the issuance of the subpoenas were duly signed by filed at the registry of this court by the Petitioner Council, and the requisite fees paid, including filing fees and service fees as assessed, were duly paid by them before Therefore, those witnesses are the petition witnesses and not witnesses of this court. Indeed, the procedure for calling of witnesses by the court is by short summons as stipulated in paragraph 42 of one of the first schedule to the Electoral Act 2022. By the provisions of that paragraph, the tribunal or court may summon a witness as a witness who appears to the tribunal or court to have been concerned in the election. Clear from the provisions of that paragraph that is a person summoned by the court so motu in exercise of its powers under paragraph 42(1) that is a witness of the court and not a person subpoenaed at the request of a party to the case. In the instant case, PW3, who was subpoenaed at the request of the petitioners, is a staff of Channels Television who tendered exhibits PBH3 and PBH4, two flash drives containing third annex consultative meeting with leaders of political parties held on 26 October 2022, an interview with Mr. Festus Okoye, National Annual Commissioner, held on 12 March 2023, respectively. PW4, a professor of mathematics, who was engaged before the election by the petitioners, and whom the petitioners presented as a subpoenaed expert witness, stated under cross-examination by the first respondent that he concluded his report on the 19th of March 2023 before the petition was filed. PW5 is the staff of Arise Television, who also tendered exhibit PCG2, a flash drive showing the INEC chairman delivering an address at the Chatham House, London, UK, on the preparations for the 2023 election in Nigeria. PW6 is the staff of African Independent Television, AIT, who tendered exhibit PCH1, a flash drive of the program Democracy Day, anchored on 22nd November 2022, wherein the INEC chairman was shown giving a brief on the preparations for the 2023 general election. PW7, who claimed to be a cloud engineer and architect working with Amazon Web Services Incorporated, tendered exhibits PCJ3A to F, which are 6 reports of Amazon Web Services AWS health dashboard, which she said she downloaded from the Amazon website. Under cross-examination, however, she not only admitted that she is a member of the second petitioner. Please, let us be serious. This is a serious matter, it's not a black. She not only admitted that she is a member of the second petitioner, the Labour Party, but she had contested election as a candidate for the second petitioner for House of Representatives election, conducted along with the present election on 25th February 2023. PWF, who claimed to be a cybersecurity expert, engaged by the Labour Party on 10th March 2023, stated that he produced his preliminary report on 17th or 18th March 2023 before the petition was filed. He tendered exhibit PCK1, a metadata. PW9, a staff of Women and Child Rescue Initiative, a non-governmental organization, claimed to be an observer in the 25th February 2023 election, but stated that the subpoena was addressed to him personally and served at his village address. PW10 claimed to be an annual ad hoc staff who acted as a supervisor. He stated under cross-examination that the subpoena was addressed to him personally and not through INEC. PW11, who is a staff in the Legal Services Department of National Information Technology Department Agency, NIFDA, stated that the subpoena was addressed to him personally instead of his organization. As for PW13, who claimed to have acted as a presiding officer in the 26th February 2023 election, he stated that he was on a subpoena. The subpoena, which was admitted as exhibit PCR, was however addressed to him personally and not through INEC. It's pertinent to observe that the above 10 witnesses in by the petitioners were all witnesses who were available to the petitioners at the time of filing the petition. They were neither subpoenaed as adversaries nor subpoenaed as official witnesses. It is therefore beyond controversy that the witness statements on both of those witnesses, filed after the time limited for presentation of the petition had lapsed, are incompetent, and the same witnesses had no value to testified in this petition. Their testimonies are embodied in their respective witness statements on oath, being incompetent and accordingly struck out. With regard to the respondent's objection to the admissibility of documents tendered by the petitioners, the first objection raised by the respondent is to exhibits tendered through PW4, as to exhibits tendered through PW4, 5, 6, 7, 8, and 8. These are exhibits PCD1, PCD2, PCD3, PCE1, PCE2, PCE3, PCE4, and PF2, tendered through PW4. Exhibits PCG1 and PCG2, tendered through PW5. Exhibit PCH1, tendered through PW6. Exhibits PCJ1, PCJ2, PCJ3, A to F, and PCJ4, tendered through PW7. And exhibits PCK1 and PCK2 tendered through PW8. These the same exhibits I have accumulated them in the judgment. The respondents' essential arguments is that till the subpoenaed witnesses and their witness statements on oath are incompetent, the documents tendered through those witnesses are not be countenanced by the court. By paragraph 41.3 of the first schedule to the Electoral Act 2022, oral examination of witnesses is not allowed. Witnesses are only to adopt their respective written depositions and tender in evidence all disputed documents or other exhibits referred to in their depositions. By paragraph 4.5b of the schedule, such written depositions of the witnesses must be filed along with the petition. In the above exhibits are documents, including expert reports, which were tendered through the subpoenaed witnesses, whom we have already declared incompetent, because their witness statements on oath were filed in violation of the mandatory provisions of paragraph 4.5b of the first schedule of the Electoral Act 2022. The documents admitted through them, which form part of their evidence, are inadmissible and liable to be expunged from the record. In the case of Buhari and INEC, the petitioners have also argued that since the parties have agreed during pre-hearing session that documents properly certified by INEC will not be objected to, and the same documents were tendered from BAF pursuant to pre-hearing order of this court of 23rd May 2023, the parties are bound by the order of the court, since the same has not been appealed against by the second and third respondent. However, this contention of the petitioner does not represent the position of the law. It states that a court is not permitted in any event to admit an act on late. It states that a court.
Are you watching the election petition?
Permitted to act in any event to admit an act on legally inadmissible evidence, even if such evidence has been admitted by agreement of the parties or under order of court in the course of hearing. Once such evidence is legally inadmissible, the court must reject it when giving its final judgment, even if that will amount to overruling itself as well doing. Ishanu and Afribank are way for JSC. Indeed, even in the case of Sani and Akwe, relied upon by the petitioner, this court at paragraph 20, paragraph 8, restricted the position of the law that even when pieces of evidence have been improperly receiving evidence, that court as well as appellate court have the power to expunge it from the record and decide the case only on legally admissible evidence. On the objection of the respondent to the admissibility of the documents tendered as expert reports by the petitioners, which were admitted as PCD1, PCD3, PCE1 to PCE4, PCD2, PCD3A to F, and PCK1. The respondent's contention is that they are caught up by the provisions of Section 83, Subsection 3 of the Evidence Act 2011, having been contrived for the purpose of this petition. It is certain law.
In your host there. Oh, sorry. Oh, really?
It is certain law that as provided in Section 83, Subsection 3 of the Evidence Act 2011, and pronounced upon in several decisions of the appellate court that a document which is made by a party interested in attending or anticipated proceedings involving a dispute as to any fact which the document tends to establish is inadmissible in evidence That's in Latoja and Ajimobi, where the Supreme Court, Peter Odili, just held as follows: the court. In respect of what is referred to as the person interested, I shall refer to the cases of Nigeria Social Insurance Trust versus Cliffco, Nigeria Limited. As regards the phrase, the person interest, I agree with the respondent that the phrase has been examined in the case of Ivan versus Noble, where a person not interested in the outcome of an action has been described as a person who has no temptation to depart from the truth, one side or the other. A person not swayed by personal interest, but completely detached, judicial, impartial, independent. In other words, it contemplates that the person must be detached, independent, and non-participant, and really not interested which way in the context is goes. Normally, a person who is performing an act in official capacity cannot be a person interested under Section 91 of Section 3, which is now the Section 3. I think the phrase, the person interested, ever more so has been quite definitely put in the case of Halton and Halton, mean a person who has pecuniary or other material interest in the result of the proceedings, a person whose interest is affected by the result of the proceedings, and therefore would have no temptation to avoid the truth, to have his personal private sense. It does not mean an interest in the sense of intellectual observation or an interest purely due to sympathy. It means an interest in the legal sense, which imposes something to be gained or lost. PPC and Ombugadu, when considering and determine who is a person interested under Section 91.3 of the Evidence Act 2011 does. By the provision of Section 91.3 Evidence Act, a person interested is a person who has a pecuniary or other material interest and is affected by the result of the proceeding, and therefore will have no have temptation to pervert the truth, have his personal private end. In fact, it is in its most recent decision in Electoral and another versus Anet, the Supreme Court, arguing JSC restated this position the following words: the other evidence adduced by the appellant to prove their case is the expert analysis report prepared by PW1, who by his own admission is a member of the second appellant and had been a special assistant to the first appellant and was engaged by the appellant to establish the invalidity of the results in Form ECFA for the 744 polling units. It is right further that I made the report as directed by the petitioners and that I am part of those who wrote the petition. By his own testimony, he established that he was not an independent expert, as he had an interest in the subject of his analysis, carried out the analysis from the conclusion that the results were invalid. Testified to support the contemplated election petition. It was an analysis from an answer and not from a question. Such a report is not the product of an independent, impartial, detached, and professional analysis. He is clearly a person with the disposition or temptation to depart from the truth. The listing of the expert analysis report in the petition among the documents will be relied on to prove the petition show it was made in anticipation of contemplation to be filed. A report having been made by PW1 as a person interested in the subject matter of the petition, when the petition was anticipated, to establish that the election result was invalid, not admissible evidence by virtue of Section 83.3 of the Evidence Act 2011 as ended. Close of court. In the instant case, EWO, who claimed to be an expert, was contracted by the petitioners before the election to carry out data analysis on the results of the presidential election held on 25th February 2023. He even tendered his letter of engagement by a second petitioner, dated 20th February 2023, which was admitted as Exhibit PCF2. According to him, he produced his initial report on 19th March 2023. His report was made a day before this petition was filed, on 20th March 2023. Obviously, the report, Exhibit PCD1, PCD3, was prepared in anticipation of this petition. As for PW7, who also claimed to be an expert witness, he admitted that she was not only a member of the second petitioner, but had contested the House of Representatives election under the platform of the second petitioner, which election was conducted the same day with the presidential election on the 25th of February 2023. He also admitted that the report she presented in Exhibit PCJ A to F are public information posted by Amazon, which she downloaded from the Amazon website, and that the open access information she downloaded in her report cannot be amended by her. This shows that PW7 was clearly not the maker of the said document. As for PW8, who claimed to be a cybersecurity expert, he stated under cross-examination by the first respondent that he was engaged by the second petitioner as an expert on 10th March 2023, and that he produced a preliminary report on 17th and 18th of March 2023, and final report, Exhibit PCK1, at the end of May 2023, while this proceeding pending. There is therefore evidence from the above that PW4, PW7, and PW8 are persons interested in the outcome of this proceeding. The reports produced by PW4 and PW8 qualify as statements made by persons interested in anticipation or during the pendency of this petition. As for PW7, he is admittedly an interested party, having been a member of and even contested election under the umbrella of the second petitioner. Her interest is further underscored by the fact that she admitted under cross-examination that she was attending court throughout the proceedings prior to her evidence. By virtue of Section 83 of 3 of the Evidence Act 2011, the report tendered by those witnesses which form part of their evidence are inadmissible. In view of the foregoing, Exhibits PCD1, PCD3, PCE1, PCE4, PCG2, PCH1, PCJ1, PCJ2, PCJ3, PCJ4, PCJ1, and PCJ4 tendered through the incompetent PW4, 5, 6, 7, 8 are hereby expunged from the record of this court. The second aspect of the respondent's objection is on the ground of improper certification or authentication. On the second respondent's objection, Exhibit PVP1 to PVP21, the IRS report for Adamawa State on the ground that no certificate of authentication of those computer-generated documents was filed in compliance with Section 84 of the Evidence Act 2011. Exhibit PCD1 to PCD6, referred to by the petitioners in response to the objection, are IRS certificates of compliance for Bayelsa, Benue, Ekiti, Niger, Ogun, and Rivers State. Adamawa State is not included in those exhibits. Exhibit PCC1 to PCC28, which include Adamawa State, are actually diverse reports and their certificates of compliance. That of Adamawa is PCC21. In short, no certificate of compliance was produced by the first respondent in respect of PGP1, PGP21. The blood IRS report exhibit PCA series in respect of Adamawa State. However, since the documents were stated to have been downloaded from Annex IRF portal and were certified by Annex as true copies of what they have in their IRF portal, the documents qualify as public documents within the meaning of Section 102 of the Evidence Act 2011, and the certification by Annex authenticates those documents. Therefore, the provision of Section 84 of the Evidence Act is not applicable to this case. This is the position of the law as espoused by the Supreme Court in the case of Ubo and Bixi, where the Apex Court held that the computers from internet-generated documents printed from the website of public institution is a public document, only a copy of such document which is duly certified in compliance with Section 104 of the Evidence Act 2007 admissible. That I've cited the Supreme Court by Akas ASC Court. Exhibits PBT1 to PBT21 having been downloaded from any report and duly certified by any are clearly admissible. As for the fourth respondent's objection to Exhibit PCG2, a flash drive tendered by PW5, the staff of Arise TV, it is clear that the said witness had in paragraph 612 of his witness statement on oath not only stated that he participated in all stages of the recording, production, and packaging of the flash drive, but he had certified the process of the production as required by Section 84 of the Evidence Act. On the fourth respondent's objection to the admissibility of Exhibit X2, on the ground that the Exhibit X2 was obtained by the petitioner from the registrar of this court and not from the custodian of the original copy, we have examined Exhibit X2, which is the European Union Election Observation Mission Nigeria 2022 final report, as rightly observed by the fourth respondent. The photocopy of the document is certified by the Secretary of the Presidential Election Petition Court and not any officer of the European Union Election Observation Mission, which is the custodian of the original copy of the document. By Section 104(1) of the Evidence Act 2011, secondary evidence of any public document only admissible in evidence if it has been certified by a public officer having custody of the original copy of the document, who by that section may give a copy of them to any person who has a right to inspect, together with the certificate written at the foot of that copy that it is true copy of that document or part of it as the case may be. Under subsection 2 of that section, the public officer is enjoined to certify same by subscribing his name, official title, and date, and where he is authorized to use a seal with his seal. Clearly, the registrar of this court, who is not the custodian of the original copy of X2, cannot validly certify that document under Section 104(1) of the Evidence Act 2011. The commissary and Arebashola Manuel Vasumana, where with JSC stated that the whole essence of the court's insistence on the scrupulous adherence to the certification requirements of public documents is to vouchsafe their authenticity vis-à-vis the original copies. Since Exhibit X2 has not been validly certified, it is inadmissible in evidence. Accordingly, Exhibit X2 is expunged from the record. The third aspect of the petitioner's objection to the petitioner's document is on the ground that the petitioners failed to plead specific facts over the documents objected to. Said documents objected to by the respondents are assuming they have been listed in this judgment. Every judgment you will see them. I have carefully examined the petitioner's pleadings and the documents objected to by the respondents. The petitioners have specifically advised in paragraph 101 of the petition that they will rely on all the first respondents' electoral and all other necessary documents used for the conduct of the presidential election, including the documents which they listed as items A to PCC, that paragraph. However, election petitions are sui generis, and it is certain that for an averment in an election petition to be competent, material facts relating to complaints made therein must be pleaded. Belgore, Ahmed, Yazu, and Ochi. In the latter case of PDP and ANI, the Supreme Court was categorical